You're on the spotlight. When I was talking to Aaron about notices of satisfaction, which are like the platform I'm running for president on, do your notice of satisfaction. You had said that you had recently come across something happening in court that our clients need to be aware of. Can you talk on that for just a moment?
Yeah, there's two things that legal aid has started doing. One is involving your notices of satisfaction. We're really good as an industry at getting judgments and getting orders of possession, but we're not great at satisfying judgments. Code says you're supposed to do it within 30 days, but if you don't do it within 90 days, there's a penalty of $100 per judgment. Legal aid, we were in court, we won the case, it involved fair housing, it was a lot of money. The attorney obviously went back to their office annoyed and tried to figure out another way to get some relief for their client. And they dug into the court case information system and found out that the client had half dozen different judgments that had not been satisfied, and sent an email saying, "Good job in court today. We'll take our $600, lots of credit on the ledger." So you got to get those notices of satisfaction in. Also, there's been a new code section enacted involving unlawful exclusion. Unlawful exclusion is really about if you go and change the locks on somebody. I mean, that's what I think of when I think of unlawful exclusion. But a lot of the courts will say, well, if they don't have heat or they don't have running water, those other essential services, then maybe you have unlawfully excluded them from the property. And that code section now gives your resident the opportunity to ask for $5,000 plus their attorney's fees, plus their actual damages. So if they had to get a hotel room or something because they were excluded from the property. So just keep in mind that you're going to see more of these cases where they're using, instead of just the tenant's assertion statute, they're going to start using the unlawful exclusion statute and start arguing to the court that this is more than just bad maintenance. This is, I can't go into the apartment because of how bad it is. And that's because they want to get that $5,000 payoff.
And my second follow-up question is, Aaron did a great job of telling us about the 5 types of notices, the 2130s, the non-remediables, and the repeat notice. I'd like for one of you guys to talk us through the process of how you interact with Senex during the time. Like, we know you do the letter, we get the letter, we serve the letter, and then what happens from there? What are the best tips for how we should deliver the letter to our residents, etc.?
So, thank you, Danja, for giving me the question that I wanted you to ask. So basically, this is the nuts and bolts of it is, well, how do you do it? Obviously, you can do it on your own. If you want our help, though, if you want our assistance in drafting the notice, email attorney@SenexLaw. Send us the information we need. Send us the details of the notice, and I promise we'll turn it around very quickly. And again, that's attorney@SenexLaw. On your coaster is the telephone number, and I don't care what order you do it. Most efficient order is email us the information, then call us. But if you want to call us because it's conduct, the police over there, there's some incident, do that, and we'll tell you by telephone what we're going to need in order to get that notice generated. So you email us, attorney@SenexLaw, call us, 804-90-SENEX, and that's 73639, I believe, is the number. Once the time period has passed, if it's an immediate non-remediable, as soon as you issue that notice or serve it, and we have at the bottom of the notice, you can do that by mailing a copy, or you can post it. Knock on the door. If they're there, hand it to them. If they're not there, you tape it to the door in a sealed envelope with their name and unit on there. That's how you serve it. Once that happens, if it's immediate non-remediable, well, just send it to us. Data@SenexLaw. Data is where you send the request for those conduct-based unlawful detainers. Once we get that, we'll turn that around quickly and we'll get the unlawful detainer filed. If it's a 2130, remember, you've got to wait that 30-day period before you send it. So do the notice, the 2130. After the 21 days, if the condition reoccurs or if the condition has never been resolved. Say it's a property condition where they're supposed to do, I'll take a mobile home, manufactured home, they're supposed to do some repairs or clean up the yard or the surrounding areas, and they haven't done it. You go by, you do a re-inspection after the 21 days. They have not cured it during the 21 days. Well, on the 30th day, 31st day and beyond, email us data@Senex Law, and we'll prepare that unlawful detainer. The notice itself has all these dates in it, so you'll be able to look at the notice and know when things happen. Of course, the date in the immediate is immediate. So that's the kind of nuts and bolts. Attorney at Senex Law for help, and then once the time has passed, data@Senex Law.
Does anyone have any questions? Can you raise your hand? Yes, can you talk louder?
Just to clarify, Aaron, on the death. So one person on the lease, they pass away, the lease ends, I can change the locks. There's an unauthorized occupant. I have to give them the 10-day before I change.
Yes.
Okay.
Have to give them the 10-day.
Okay. Part two.
The question was, if somebody dies in a unit and there's unauthorized occupants who are in there, what do you do? You still got to give that notice. Now, the code says that all of the occupants are supposed to vacate on their own within 10 days of the death of the resident. They don't know that. The code doesn't say you're required to send them a notice, but the judges are looking for that notice. They want to see that you gave them a 10-day notice to get out. So give the authorized or unauthorized occupants that 10-day notice, and then if they to vacate. And then if they don't leave, then we can file the unlawful detainer on day 11.
Okay. Second part to that, kind of similar scenario. The leaseholder moves out because they've given proper notice to vacate. Again, there's unauthorized occupants. They don't want to go because maybe they don't have any place to go, and they remain in the apartment. Is it considered a non-monetary, but then rent becomes due? Or is it a monetary, but they were never on the lease, so can I hold them for rent? Sorry, that was kind of a confusing.
No, so the question is, what happens when a resident gives you notice that he's going to move out, and then he moves out but doesn't remove his occupants, authorized or unauthorized? We're still going to have to file an unlawful detainer to get them out. We can't just a non-monetary. And what we'll want to see is the lease. We'll want to see their notice of non-renewal that they gave you, their notice of intent to vacate. We want to know the facts of that case. Did they turn in their keys or did they just leave and you think they're gone? Most of the time, we're going to send a notice to the unit addressed to that resident, telling him you have not relinquished possession properly, you have unauthorized occupants, you need to get rid of them, and that resident will still be rent responsible until the end of the lease or until you get that unit back.
Okay. Thank you.
Sure.
Anyone else? Yeah, speak loud, please.
No problem. So to piggyback off that, what if you don't necessarily know that they're an occupant or an unauthorized occupant? You go, there's a check, you change the locks immediately, and then someone comes in and says, I'm living in that unit. What do you do at that point?
Let me see if I heard it all. You have a death in the unit. You don't know whether they're authorized or unauthorized, and then you said change the locks immediately. And I want to. Did you say, is that your fact pattern? What's the question?
Somebody
You
appears.
had a death. There was no, to your knowledge, there's no one living in the apartment other than the leaseholder, which is one person. Someone comes back after the fact and says, my key's not working, I was living in the unit, but they were not on the lease, and they were not living there to your knowledge.
All right. So the lease only has a single leaseholder, no authorized occupants. That single leaseholder passes away. You give the 10-day notice. 10 days expire. You change the locks. Day 11, somebody comes in and says, my key doesn't work. This is going to be interesting because I think we're going to pass the microphone down and see what each of us would say. I think the answer is that the courts, and especially in some of the hotbed jurisdictions, are going to want an unlawful detainer filed because somebody has a claim of possession and the judge wants to be the one to decide whether or not it's a lawful or unlawful claim. So I believe they're going to want an unlawful detainer filed. What is not included in your fact pattern is when you change the locks, that normally is accompanied with an inspection of some kind. Normally what happens and the way the questions come into us is we went to change the locks, we looked and it was full of furniture and we could see that somebody's living there, so we left without changing the locks. What do we do? In that scenario, I would say go ahead and go through the process and do an unlawful detainer. If you've gone in a different fact pattern and there's no evidence of anyone living in there other than the named leaseholder, then you have someone come in from out of the blue. I think the better part of valor would be filing an unlawful detainer, but I'm curious what Jordan or Aaron would say.
I was curious too.
So you've already changed the locks in your fact pattern, and the resident some person comes to your rental office and says, I live there. You don't have a lease with them. They're not listed as a leaseholder or an occupant on the lease for the person who was living there. You don't have a time machine, so you can't go back in time and undo what you've already done. Your two options really at that point are change the locks back and let them in and then file the unlawful detainer. Or tell them, we don't know who you are, we have no relationship with you, you can't move back in, and we delivered a 10-day notice to the emergency contact. Maybe after 10 days you let them come back and get their stuff. Remember I said, because you've got to give that 10-day notice to somebody about the personal property. The way that would play out is I think the unauthorized occupant would file something into court, an unlawful exclusion, which we were just talking about, and then the judge would look at the lease and say, you don't have any right to be there. So I do see value.
Would they say that in Richmond or Albemarle?
Now, Richmond and Albemarle, we're leaving this out to the side. I would fully agree with Patrick on that. If you're in Richmond or Albemarle, change the locks back, give them a key, file an unlawful detainer.
Did you say store at the items?
10 days.
How do you know their name?
Yes.
If they're an unauthorized occupant, they just walk up to you. They should provide ID, I suppose.
Yeah, I mean, you're going to have to really verify that this person does have some tie to that property. I want to see that they're getting mail there. I want to see that their driver's license has that address. It could be anybody who's trying to get that stuff. So I don't see anything wrong with, and I'd be happy to argue in court that you did everything right to protect the property of the decedent. But ultimately, if we had to file something against them, we would file it against any and all occupants. And that would be the defendant in the lawsuit. And whoever shows up to court and says, I'm one of those occupants, will get to speak. Another question.
So my question would be, piggyback off that, I know it's sort of a 10-day notice, right? Well, do they not still store their stuff for 30 days? Because they're just going to sell their stuff.
You don't have to store the stuff for 30 days. You've got to give 10 days notice. I'm not aware of any law that would require you to store it for 30 days.
Wrong state. Wrong state here.
Yeah, and let me throw out one other thing. I know one thing that Aaron mentioned in passing, if you will, is the ne'er-do-well son shows up. He's the first one to the property management office. He wants access to the property. My standard advice is do not give him a key because he's not on the lease. He's not authorized to even get information. You're not allowed to give him information about the file. However, if the ne'er-do-well son shows up, has his key, and is busy unloading the apartment, buy some Gatorade, get some pizzas, make sure they are well rested so they get it cleaned out completely. Because they are doing you a favor in moving. I do not ever want you to show preference for one child over the other, or whoever shows up, if they want to gain access to that unit, they have to have access to that unit. The statute is really funny in this way. It says you've got to give the estate legal notice if there's an executor appointed. Well, by statute, I think that's 180 days before they can be appointed. And if you're not moving faster than 180 days, we've got problems. So the reality is you're going to be given notice to that emergency point of contact. It is enormously important that you keep that up to date because you legitimately want a good quality conversation with that point of contact. You want to say, hey, listen, 10 days, they're focused on their loved one, they're focused on the passing, and they're not concerned about it. They're thinking, oh, we'll go down later this month. Well, later this month, it'll all be gone. You want that information up to date, so you call and have that, obviously, express your condolences. I just want to make sure you know how time sensitive it is, that kind of thing, so that the family does have the opportunity. That's the only person that you know with certainty you're allowed to communicate with. I suspect you could modify, and this is brainstorming, I suspect you could modify that form and say, I give permission to release keys to the following named individuals, and then you could do it.
So we've taken over some properties, and one that I'm on now, there was that form from the prior management company that said, in the event of my death, I release my items to this person. It's not a bad thing to have in there.
Yeah, and Lori was saying she took over a property that had a form that said, if I pass, release my personal items to anyone named here, and that was helpful in that situation.
I have a question for the room. How many of you update your files yearly? Yeah, I think it's a great idea from what we're learning here, not only for this emergency contact that you're going to have to deal with, but also for the collection items that Patrick was telling about. You want to get that fresh info for the military status that you're working on. If you're doing it every year, you're checking in on your residents and just letting them know, or actually letting them let you know what's going on in their lives. Any other questions from the audience?
I got one. Actually, two.
Okay.
So if we have an unauthorized occupant going kind of in the same scenario here, but they have utilities established in their name, does that qualify them as a resident if they're paying bills for that address?
So the question was if a unauthorized occupant is paying utility bills or has some other tie to the property, does that make them then a resident by default? No. They need to sign the lease and be a leaseholder. What it makes them is an unauthorized occupant who's spending money.
Okay. Secondly, if we have a resident that passes, but there is a secondary leaseholder, but they no longer income qualify.
So the lease is going to continue, and they're going to be in that lease until that term ends. So they don't have to re-qualify because someone died. Now, if you have requirements because you're a tax credit property or some other property and you're in a program, typically the program will dictate what you have to do at that point. But if you're just talking about a conventional property, they stay in there. And you can obviously non-renew the lease if you want, but they're in there.
Next question, guys? Yes, in the back.
I have two. Are there any upcoming legislation changes to the late letter that's going to require us to send them in English and in Spanish?
The question is there any anticipated legislation in the pipeline that might require creation of English and Spanish language documents, notices, leases, and so forth? Everything I've seen, the Department of Housing and Community Development has a mandate to prepare certain draft documents, for example, a draft notice. That mandatory language or statute telling them what to do then says, and if you're able, do something in Spanish. So even DHCD in preparing template documents is not yet mandated to prepare Spanish language documents. So I can see it on the horizon, but I think it's more 3, 4, 5 year horizon. I think they're going to try to get it in plain English first, and I think in my lifetime it'll be 14-point font in 4th grade readable English. That'll take about 7 pages, given the clarity that we're going to have.
You have a second question? Yes. So if you have a boyfriend and a girlfriend on the lease expires and the girlfriend gives proper notice to vacate, but the boyfriend did not. Girlfriend turns in her keys, and after the notice to vacate expires, what do we do from there? Are they both still rent responsible? How do we go forward with continuing the lease or ending the lease?
Red Rover send Jordan. Jordan want to do it? No. All right, Aaron, it is.
I had that exact case happen, and the judge said so this is where you have got 2 residents, and one of them puts in a notice to vacate and leaves at the end of the lease term, but the other one doesn't. When we got to court, the judge said, well, the one resident who put in her notice to vacate and turn in her keys did everything under her power to get out. So I'm not going to hold her rent responsible and would not let us get a judgment as to her. But he did give us a judgment for unpaid rent as to the person who stayed behind. You can also issue your notice of non-renewal if you want to get them out and he's not leaving. We can check your lease too. Sometimes the lease will say notice from one resident constitutes notice from all residents. And the fact that one resident gives you a notice that they're going to vacate and the other one doesn't, we can file an unlawful detainer against the one that won't leave based on the notice and the way the lease is written. So it is going to come down to the words on the page, but there's different avenues we can take to get them out, or you can just let them stay and continue to pay rent. Nothing's requiring you to evict them if one person vacates.
At that point, would we have to change the name on the lease to remove her and keep him going forward?
I would encourage you to keep your records up to date and have her removed from the lease that way, through it happened.
Aaron, actually hang on to that for a second. So with our company, 2 residents want to move out, or rather one wants to move out, one wants to stay. We don't sign our section basically until we have both signatures. So it's just them coming in saying I'm moving, or emailing saying I'm moving. Is that enough information, or is, if we're not signing off on it, we're not accepting it? At least as far as we're concerned.
So I think I understand your question. You're saying that you would like to sign off, your company signs off on every notice to vacate.
Yeah. 2 residents, you have, say if they're working different hours, you might have the first guy come in at noon, the second guy comes in at 3 o'clock, we countersign everything, they get a copy, we get a copy, everything's happy. If they're not agreeing, same situation, first guy comes in, second guy doesn't come in, you don't sign it at that point.
So the first guy's going to leave, right? He's telling you he's going to leave, and whether you like it or not, whether you like his email, whether you like, if he turns in his keys, first problem you're going to have if you try and sue him is getting service of process, because he's not there anymore. We don't know where he's at. So in all likelihood, the lawsuit would go just against the one party, but we're going to have questions for you. Did he turn in his keys? Did he, what happened at the end of the relationship? Or did he just say, I'm moving? And that's the last you heard. If that's the last you heard, then we would file our action against both parties. They're both still going to be rent responsible unless, like I said, that we get the judge who said, what more could this person do other than, and that person did everything right. Gave the keys, did a move out, walked through, said, I'm out of here, but the other person refused to leave.
Flip that over and say if you have someone saying, I'm leaving, I'll bring this back and have my roommate sign it, and they sign it for their roommate and the other guy has no idea. I've had that happen before.
Are we ready for drinks? I have not had that happen before. I mean, you've got a forged document. He says, what if one resident signs for both parties? How would you know that would be my question.
The move out day, we called the second resident up saying, hey, when are you dropping your keys off? And he's like, I'm not moving, where's my furniture?
Well, I think the bottom line is you're not going to want to change the locks on that person. You're going to want to file an unlawful detainer and have a judge make that decision.
Like it, Rich. Challenging question. Bring it on. Brandon, the back.
Okay, I have a question about our renewal letters. Is there any kind of legal verbiage that we should have on our renewal letters?
He said drinks, and I can't get past that.
Was, is there any legal verbiage that should be in your notices of non-renewal? The answer is yes.
Regular yearly renewal.
In your renewal, I think that's going to come down to what your lease says has to be in there. Whatever you guys agreed to at lease signing is going to dictate. I mean, that lease, these leases I'm looking at, sometimes 48, 50 pages long. There really is something in there that covers almost everything.
Well,
The new brand.
the reason why I asked is with COVID hit, we had to have that CARES Act verbiage on there. Is that something that we still have to have?
I don't think you have to have any CARES Act verbiage. If you're increasing the rent, you're going to want to pay close attention to what your contract says about increasing rent. The Blue Moon lease, the NAA lease says you got to give 15 days notice in advance of their time to non-renew. So if your lease says 60 days notice of non-renewal, they want you to give 75 days notice of the change in terms and conditions, the increased rent, so that the resident has at least 15 days to decide if they can live with it. And if they can't, they still have the time to give you a 60-day notice of non-renewal. So you're going to want to pay close attention to what the lease says.
Okay, well, here, we do 120 days. So we have the time.
Sure. You're ahead of the game. No, you can give notice. Notice of non-renewal says typically 60 days. Most of them say 60, some say 90, some say 30. 60 days notice, that's a minimum. You want to give them 120, that's great.
I have a follow-up question to that. What have you been seeing with unsigned renewals in court?
So, piggybacking on Aaron's answer, when you were doing the CARES Act language in the notice of renewal, that was in 2020 because from March 27th, 2020 through July 25th, there was a prohibition on notices to vacate. And a notice of renewal is also an invitation for them to non-renew, and therefore it was construed as a notice to vacate. That requirement evaporated July 25th, 2020, so that is why that language is gone.
So,
What are you seeing with unsigned renewals in
Okay.
court?
So there are three different statutes and that kind of touch on this piece. But here's kind of the biggest piece of it. At the time of renewal, you ordinarily don't have to give any sort of written notice if it's just an automatic renewal and you're not changing anything. Typically, owners do not like to do that. Owners want you to at least have a 3%, 4%, 6%, 20%, whatever they can get away with, increase in the rent. That has to be done as part of the renewal process. Any other changes, for example, say you added the trash ferries or some other ancillary income source that is now, you've launched it, you've been charging all these fees to these residents that they never agreed to. Well, now that's an issue. Now you're doing the renewal. Make sure all of your new services are covered by that lease. Part of that annual lease audit that you ought to be doing should be verifying that all of the charges on the ledger are actually authorized in writing by the resident. So if they have not yet authorized trash ferries and all of their fees or utility billing service or whatever cable or amenity fee, whatever you have, all of those ancillary fees, if they were not part of the lease that is in their file, your lease renewal is where you do it. The process is 120 days, 75 days, whatever it is before the renewal. You send them out the new terms. Say, these are your options. You can move out. You can renew short-term, medium, long-term, whatever it is. These are the rates. These are the terms that apply. In addition, we're adding this new addendum, or we're adding such and such. Anything and everything you want to change on the lease has to be done at a renewal. You mail it to them. They get it. they accept all of the changed terms purely by staying in the property. If they stay past the renewal date, they have accepted those new terms even if they did not sign the new documents. Their conduct equates to acceptance. That includes any change in terms. If they move out, that is the lease ends June 30th. You gave them 75 days notice, and June 30th they come in and you find out they're gone. Well, they have rejected the renewal. They have exercised their right to vacate. That is not a liquidated damages kind of thing. They moved out at the end of their lease term, and that's all right. And they never signed anything in either of those scenarios. The final scenario is they do sign it, or they sign some and not all of it. And all of that's fine because you've gone through the right process.
My question. How do we differentiate that from if they don't sign the notice of renewal and they're remaining there? At what point does it default to a month-to-month and the month-to-month charges apply? Because I see that happen more often than non-signature of a renewal.
So their conduct in staying is an acceptance of the new terms and conditions. When they have stayed longer, so the terminology is holdover versus renewal. So if the lease automatically renews, then they're just a regular tenant and these new terms apply. If the lease has ended, say for example, you've issued a non-renewal and June 30th is the end and they still stay. They are what's called a holdover. And the terminology is a little different, but from your perspective, you still accrue rent, you still put those charges on there, there's still a move-out inspection when they ultimately move, and all of that is the same. It matters to us from a legal standpoint in how we phrase some things on the unlawful detainer and how we communicate with the court, but at the end of the day, the result is the same. Their conduct of staying in the unit accepts is a continuance of the existing obligations. If you've modified those obligations, those now apply. And in Aaron's earlier example, where you have one resident's done everything they could to get out, I mean, I think all of us, maybe you haven't done enough yet, but within 6 months, each of us will have yet another example of this. Typically what happens is it's a family member, mom is left, children are there, the children are left, and the mom's still there. Whatever it is, a family member is left, and the judge is trying to decide, well, should that remaining family member carry the financial responsibility alone? Is it something they both shared? Those are the familial relationships are the ones that are most difficult for the judge to reconcile. The roommate situations are easier for the judges to reconcile so long as it hasn't gone on forever. If you've done a lease renewal in the middle and you know that other roommate's not there, but they're probably going to release that resident that's no longer at the property.